Mr. Speaker, ladies and gentlemen, the reason why the Brady Rule with Brady versus the state became a landmark case for the legal profession because at that time, prior to reform and amendment, a lot of people were being overcharged and serving harsher sentences than they otherwise deserved. And in many cases, the biggest harm it tried to mitigate were people being falsely accused and falsely convicted for things they did not commit. People who were poor, people who were racial minorities, and people struggling to be able to fight against the big powers of the state. The immense power that the state prosecutors have also an equal and heavy responsibility because these people are also arbiters of the law for Lady Justice. In all cases, contrary to how civil cases work, the nature of prosecution for criminal charges, Mr. Speaker, is the state or the state prosecutor representing a particular locale or representing a particular country against an individual defendant. In these cases, as what Matthew suggested in his point of information, carry out an asymmetrical power dynamic wherein these particular defendants or normal people like you and me have every significant disadvantage. And we think because of how the law works, Lady Justice is blind for a purpose, and the Brady Rule was meant to make that better. State prosecution lawyers have every obligation to follow the Brady Rule in order to be able to uphold fair and equitable outcomes in order to prevent the arc of justice from bending towards the state, who in many cases have the money, have the network, and have every capacity to be able to forward what they would want. And as we suggest, and I understand that all legal systems are like adversarial, this can actually make things even more adversarial and even more deadly for these defendants at the point in which, like what I mentioned in my pre-oration, these people get overcharged and severely overburdened. The case of the first speaker presupposes that it works in a vacuum, but we need to understand that in order for due process to be upheld, we need a total and complete picture so that the judge and jury will be able to understand and rule in equitable favor. A few things coming from our side of the House. Number one, this is a value judgment debate from the lens of a neutral observer. This is not an actor motion skewing it to the perverse or selfish intentions of that particular prosecutor as a lawyer. We need to understand that the goal of both sides in this debate is to be able to uphold due process and prevent over-sentencing. On side proposition, you're likely to be able to be the victim of things like cronyism and dirty politics, wherein these particular people, because like what Matthew mentioned, having things like police power, are literally able to withhold evidence that impede on the ability of the state to make a proper decision in the eyes of the judicial system. Before I go, POI, go. Go. Yeah.
Already go ahead and agree that things like this are problematic. That is why Brady was established. But a lot of legislative changes are current. You still need to engage with a framing that the current welfare state mechanisms helps people with the judicial systems inherently, and you do not need Brady exactly for that. That is our case.
Very simple. The Brady Rule makes these things better because as it evolves, we also have every mechanism that you also have on your side to be able to make it better. The simple push is that when there's an incentive structure to be able to forward evidence and do this in an equitable way, we're able to get a more fair ruling for these particular defendants if they deserve it or not. Second push. On both sides, we're going to have a trial, and this bolsters my response to the point of information. The prosecution, along with the judge, are going to be able to, at some point, be able to share evidence back and forth from both sides, being able to share their stances. They will determine if these things are admissible or not, and they're going to determine the extent of change, if any, that this smoking gun or this new evidence is going to do. And we think simply because of how the criminal justice system is orchestrated, they have every principled and practical obligation to be able to uphold it. Because they're not beholden to that particular individual, they're beholden to the state as a state prosecutor. We think, especially during the preliminary investigation, this is exactly where sharing this contentious material matters the most. Here's the kicker. The prosecution, in majority of cases, have a bigger and higher burden to be able to determine things like probable cause, because they have a plethora of resources, things which include but are not limited to state money and capacity, networks of lawyers and private investigators, police powers and the ability to intimidate, fabricate, and even hide evidence in order to convict that minority, that black person, because you already have a predisposed prejudice against that individual, bending the arc of justice against them. Thirdly, something quite important. This debate obviously happens at the point in which that evidence is of paramount importance to swaying that decision. On both sides, this evidence will be scrutinized. On both sides, the legalistic mechanisms will be used to be able to gather and make the most informed decision. But the impact is simple. On their side, number one, you undermine the nature of the criminal justice system. Because I agree with the previous speaker. The defendant is innocent until proven guilty, but the point in which you run this trial with incomplete information because they could claim ignorance or they can claim malpractice makes it ultimately harder for them to be able to get due process. The second is you wreck potentially innocent lives. These particular people who are trying to be able to go against the strong man, a David and Goliath kind of legalistic and judicial narrative, makes it significantly harder at the point in which they're likely to have less resources and capacity to be able to do it. Ladies and gentlemen, the push coming from side opposition is quite simple. We want a clean and fair trial, and that can only happen when these particular state prosecutors have every obligation to look at the complete picture, even if it means the particular defendant having a lesser sentence or in many cases even let free for something that they did not commit. We are very proud to stand on side negative.